So I wanted to ask you about navigating employment agreements, specifically the more unconventional ones. So we're noticing now a lot of employers putting in place, perks like bring your dog to work and paid time off, sort of unlimited. How do we navigate that? And also, how does that fare for the employee once they're terminated?
Yeah, I mean, so those are all interesting questions. First of all, service animals are always welcome at workplaces, unless there's a competing issue like an allergy. But I would think for the most part, you could probably still make that work if the office is large enough. And also, we have remote working and hybrid working scenarios.
Right.
So, I would think that I love dogs. So for me, I'd love to have, if you have a dog, you want to bring it into work,
I do have a dog.
well, then you should bring your dog into
He's a big
work.
dog. He's a crazy dog.
I think we talked about this before,
We have talked
actually.
about
Yeah,
it.
yeah, yeah,
Yeah.
yeah. Well, if you want to bring your dog, bring your dog. I think that makes a lot of sense, right? If it helps anything that helps your workplace build camaraderie, anything that helps keep people on task, anything that makes people more productive, not less productive. And productivity is a funny thing too, right? It's not about time on task necessarily. It's about the quality of work that people are putting out, right? So anything that assists, I think for the most part, employers are going to make room for it. I think that's one of the reasons that hybrid and remote work have persisted beyond the COVID lockdown in the way that they have. I mean, they're a real feature of work in Toronto and Ontario now, for sure. Although, I'm hearing from a lot of hybrid and remote workers that they would welcome a return to the office if the offices were set up to accommodate the type of office return that they'd like, sort of larger meeting rooms, communal rooms, common spaces, kind of like this one here, actually. Right? I mean, that's one of the things I love about this office is that we have a physical office, and then we also have the ability to move out and about. We've got this outdoor space here. It's beautiful,
Yeah.
right? I think
Yeah.
that, environment, maybe that's what I'm trying to say. Environment is important, especially to younger workers. And employers that don't think about that or consider that, or maybe they're missing out on some quality talent as a result.
Yeah. So it definitely has a benefit when you're recruiting and trying to, I guess, maintain the employees that you have. But have you noticed, does it affect sort of the termination
Oh,
in
yeah,
terms of
yeah,
like
yeah, yeah.
litigation when there's some sort of unconventional
Sure.
aspect to the agreement?
Well, you mentioned unlimited paid time off, right?
Yeah.
So that's an interesting phenomenon to me, right? The idea that you should just take as much vacation as you need. It really presumes that the product that you're turning in is excellent and worth the compensation that the employer is paying for it. It almost converts the employment into sort of a contractual relationship. Deliver the products I ask for, deliver more, or deliver at least the quality that I'm expecting.
Right.
And I don't care if it takes you 1 hour or 10. I think that's an interesting idea. I think when you get terminated, what happens with your leave entitlement? I could figure it out, but short answer off the top of my head, I don't know. Right? My guess is that it's probably very, very hard to prove that you haven't used the vacation because nobody's tracking, but the obligation to track vacation is actually the employer's. And so my guess is that in a contest, it would be the employer that might find themselves in an unfortunate position, perhaps owing additional vacation pay pursuant to the Employment Standards Act minimums.
Right, because they haven't actually recorded any
That's right.
vacation.
The record-keeping obligation. Employers forget this all the time, especially small and mid-sized employers. The record-keeping obligation is not the employees; it's the employers. And we talk about this all the time. It's about evidence. It's what we can prove, not what we know.
Yeah.
So, an employer, you need those records.
Yeah.
And if you don't have them, you don't have them. Right? We can help you, but it's more difficult.
You mentioned hybrid work versus kind of in-office work. Can you kind of explain the difference between those and how that may impact your contract?
Yeah, I mean, so that's interesting, right? So let's say you're a remote worker. If your contract provides that your work is remote, effectively you can work from anywhere. If you wanted to move to a jurisdiction with better weather,
Right.
if you want to move to a jurisdiction where your compensation goes further, the spending power of your wage goes further, presumably that's all doable. The problem is that really when a lot of employers say that the role is remote, it's not. It's remote, but we'd like to see you once a month, or it's remote, but
Right.
when we call you in for a meeting, we'd like to see you. Well, that kind of changes things, right? And the other problem with remote work, frankly, for Toronto employees is this. The cost of living in Canada is high. The cost of living in Toronto is exorbitant. We know that there are some structural issues with taxation, particularly on wages, right? And so if you're a remote worker for a Toronto employer and the idea is that you're going to get a Toronto wage, but you're going to live somewhere well outside of Toronto where the cost of living is much lower, don't be surprised if your employer wants to negotiate compensation with you once they realize that your cost of living is much lower.
Right.
Don't be surprised if you won't negotiate, that the employer might elect to terminate and hire somebody in the jurisdiction where you're living for less money. Right? What it really comes down to is that right now there's a labor shortage, and so employees have been able to negotiate preferable terms, unlimited paid time off, remote work.
Right.
But that labor shortage will not last, and historically that has not been the case. Historically,
Right.
unemployment has actually been much higher, north of 7%. Sure, feast while the times are good.
Yeah.
If you've built your financial circumstances around that windfall from remote work, you should at least build into your plan some flexibility if you need to return to Toronto, because this is where the work is,
Right.
if the positions are no longer remote.
Right.
Right.
So it sounds like, I mean, to some degree, the employer has a right to know like where you're living and kind of sort of, do you commute to work or do you live in the city? Maybe you can touch a little bit on that. Like, let's say you already have a job and you decide to move out of the city and start working remotely. What types of rights might the employer or the employee have in regards to negotiating, salary
It's kind of
changes?
it's more problematic than that. For example, if you could just go live in the United States while working remotely for a Canadian employer,
Right.
a lot of people might do that. They can't, right? And that's because there are tax agreements between the United States and Canada about where wages get taxed and how they get taxed,
Right.
right? And so it's actually quite challenging. One of the more interesting ideas I hear is I see people going to jurisdictions that are very far away, where the tax regimes are very unsophisticated, or
Right.
maybe not focused on income tax. It sounds like paradise,
Yeah.
but it might not be in a couple of years,
Right.
right?
Yeah.
But I find that, again, most of the people that are doing that are people who are in a position to do that. For example, single and younger workers,
Yeah.
right? People who have young children or are raising a family, or people who are contemplating children moving out of elementary school and into secondary and post-secondary education. That just might not be available for them.
Right.
I also think as rates begin to come down, which will happen when unemployment begins to climb up, that labor shortage that we've been talking about, that is the leverage that employees have used to get these sort of novel or new types of roles, it's going to start to come out of the economy. And when it comes out, the employers may want to see a return to a more traditional workplace.
Right. Which we're already seeing. I think most companies have like 3 days in the office, 2 days out of the office. Who knows if they're going to hold there or continue going back to 5 days a week in the office.
It's an interesting observation. I don't know if I agree. I think it's kind of company by company, case by case. I think a lot of it has to do with how companies measure productivity, right? And different industries have different benchmarks. Time on task can be very important in some industries, and especially if you're billing by the hour,
Right.
like us.
Right. Yeah. Well, you want to be there doing work.
See you
right?
tomorrow, Sarah.
Yeah. I'll be there.
But more importantly, if you're benchmarking productivity by the quality of the product, you're almost moving out of an employment type of contract and into something that is more of it may still be employment for the purposes of the law, but it may feel very much like independent contracting or dependent contracting, where you're delivering product in exchange for a fee, right?
So I want to touch back on something we talked about earlier, which was unlimited paid time off. So I
Still on that, eh,
understand-
Sarah?
Yeah, we're gonna stick on
I
that.
hear you. I hear what you're saying. I do.
Yeah, maybe we can
Yeah,
negotiate something.
Are we still rolling?
Yeah. Maybe you can touch on sort of how you would go about calculating that, because benefits are.
That's too technical. I think for unlimited paid time off, I think each contract is going to have different language because it's relatively new.
Right.
And so, we haven't settled on a clear form of provision, or there aren't sort of 2 or 3 ways of drafting that. The other piece is, in every negotiation, the aggregate compensation is the target, right? We often talk about this, what is the total compensation or the aggregate compensation? But for the employer, the main event is maybe they don't want to pay commissions post-termination. Maybe they don't want to pay bonus post-commission. Sometimes things like remote work or unlimited paid time off that don't necessarily have a clear economic value, we can use those as leverage, to deal with, to find ways to improve offers and still allow the employer to keep their policy interpretation, right?
Right.
So things like paid time off and remote work are great levers in a negotiation,
Right.
but they're not necessarily the main event.
So let's switch gears and look at, let's say, for example, someone in finance where their base salary may be, way less than their bonus.
Yeah.
So in that type of situation, obviously their benefits are worth more than the base salary. So how do you go about kind of calculating a package, like a termination package?
Yeah, so you raise a couple of great points, right? So the first is there's a real distinction between incentive pay, which is bonus, options, phantom shares or restricted stock units, and benefits, which can include very, very lucrative defined benefit pensions, particularly in the financial services industry, but might also include a defined contribution plan or a RSP match or perhaps an employee share purchase plan. There's lots of different bits and pieces in the compensation arrangements in that particular industry. There's also really novel compensation arrangements too, like forgivable loans. Right,
wow.
which I think fascinating structure. But long story short, the Employment Standards Act provides us with a lot of guidance, and the Employment Standards Act says that when you're looking to calculate Employment Standards Act minimums, you take all the compensation that the employee would have earned during the preceding 12 weeks, and then you divide by 12. And so if you have an employee who gets a substantial payment in the preceding 12 weeks, their Employment Standards Act minimums may be significantly higher than a mere payment of 12 weeks base salary, or 8 weeks base salary plus statutory severance, I should say. Right? So there's all kinds of interesting issues there. Beyond that, again, you get a lot of these employer plans where they only want to pay if you're actively employed, or on termination, they only want to pay base salary, or commissions will only be paid at the time that the sale closes. Right. And so how do we know if the sales which are close to closing will close during the notice period? Right? Courts are loath to deal with any of that. They will set aside those provisions. They will look to find ways to compensate an employee fairly during a period of reasonable notice. And the primary mechanism is to take an average of the preceding 3 years, whether it's commission, bonus, and then extract a number and apply that number forward. And so, most employers that are looking, if that's their opening position, it's generally not going to be their closing position. But more importantly, it's unnecessarily aggressive. It forces the employee in their negotiations to pursue greater entitlements than they otherwise would.
Right.
It's kind of like selling a house. I talk about this often.
Yeah.
If you set the sale price too high, no one's making an offer.
Right.
If you set the sale price too low, you'll get lots of offers, but many of them you won't even consider.
Right.
Well, that's fine in a marketplace. It's not great in a one-on-one negotiation.
Right.
Right?
Yeah.
You really need to set the price someplace where the negotiation has the ability or the prospect of landing in a range that you are comfortable with.
Right.
And so really when the employers are being hyper aggressive in their opening positions, what they're saying is they're uncomfortable paying common law notice.
Right.
And the problem for the employer in that case is that common law notice is enforceable. You can go to court, get a judgment,
Right.
and you still have to pay. And for the unfortunate employer, they're going to have to pay the costs of their own lawyer,
Right.
which these days can be $50,000 to $100,000 for a 2-day trial. And then they're going to have to kick costs over to the employee's counsel too. That's me.
Right.
right?
Yeah.
And so what they've done is they've taken a financial obligation and they've made it $50 to $200,000 more than it needed to be,
Right. Right. They should have
right?
just paid it out in the first place. They actually end up making it worse.
All because in the opening negotiation phase, they set the price too low, right? And
Right.
so it always sort of boggles my mind. Common law notice, it is rooted in contract, but the skill and ability required to draft an enforceable agreement is very high. And the creativity of plaintiffs' counsel, like us, will almost always at some point erode the protections that are drafted in an older agreement.
Right.
Right? There's that case that just came out, I think 2 weeks ago, that says if you use the words at any time in your termination provision, that this voids the termination section of the agreement.
Right.
That's shocking to me because those words at any time probably appear in about 80 to 90% of employment
Yeah.
termination sections.
Oh yeah. So there's probably a lot of contracts out there that have been,
Right.
essentially voided because of that ruling.
Right, and so this happened once before in the Waxdale case, where they talk about with and without cause.
Right.
The Employment Standards Act threshold was much higher, willful misconduct.
Yeah.
This at any time is going to have the same type of precedential effect, and I think actually it's productive because post-COVID, a lot of employers were alive to Waxdale. They went to their counsel and they got very, very aggressive contracts drafted with layoff provisions, Employment Standards Act only minimums. They were the contracts that were presented post-COVID were very tight. And perhaps fairly so because wages inflated significantly post-COVID too.
Right.
But this at any time is going to put the vast majority of Ontario employees who enjoy those inflated wages in position to seek common law notice if their employment is terminated.
Right. So I guess if you've been terminated recently, it may be something
You should
that
call us right away. I don't want to be too direct, but oh my goodness,
maybe
yeah.
pick up the phone. Yeah.
Yeah, like if you think
Interesting.
it's enforceable or you've been told it's enforceable in the past, there's a real chance that it isn't.
And do you think there's a chance that that case will be appealed or overturned?
It could be appealed. The interesting thing, it wasn't decided solely on that basis. I think there were 3 attacks on the employment agreement in there. And so it's possible that that case will stand. Maybe the Court of Appeal will peel back. It's open to the Court of Appeal to peel back that one exception and still achieve the same result, which I think was a just result for the employee.
Right.
I'm not as familiar with the case as I should be, but it seems unlikely that the Court of Appeal would do that. Because I do think that one area where employers still often fail is how to treat employees during a leave of absence or after a leave of absence.
Right.
And it was the words at any time were found to be unenforceable because employers do not have the right to terminate
Right.
during a protected leave of absence.
Right, like a sick leave or
You would think that you don't have to say that.
maternal
You would think that you don't have to say that in a
Yeah.
video
Yeah.
in 2024. But the truth is that there are still heavy-handed managers, and there are still managers maybe who are not getting the kind of human resources guidance
Yeah.
or legal guidance that they should be getting, who do terminate during leaves of absence.
Right.
The other thing, hint, hint, management, is, there's this idea that if you just wait 6 months, then you can terminate. That is a reprisal for taking a leave. And courts, especially when it's like 6 months to the day
Right.
or 3 months to the day, it's so obvious.
It's obvious. Yeah.
Right?
Yeah.
The other thing, if the termination is right before someone goes on vacation that's been approved or right before a statutory holiday period, come on.
Right.
Right? I know you want to make your point,
Right.
but the person who's getting the bad news is the employee.
Right.
Right? I never understand why employers want to rub it in.
Right.
It's
You don't have to
unnecessary.
make it personal
It's unnecessary.
Yeah. So I wanted to circle back to something we had discussed in our last video, talking about ESA payments and sort of when the employer miscalculates an ESA payment. I think you had mentioned that ignorance is not really a valid excuse.
Ignorance is no defense in the eyes of the law. I think that's right.
Right.
So interestingly, we were talking about this earlier in this video and in our last video as well. But so the first issue is the employer has the obligation to produce records, right? And so one of the records that an employer has to produce is a pay statement. They can't withhold that statement from you. It doesn't happen very often, but with a lot of small or, small to mid-sized employers or owner-managed businesses, I have seen the refusal to produce a pay statement for an ESA payment made post-termination. This is a huge mistake. It's bad faith, but more importantly, if I look at the payment, I will get the statement. A court will order that it be produced.
Yeah.
If I look at it and it's calculated incorrectly, whether inadvertently or not, the fact that you've refused to deliver the statement without making me go through the process of ordering its disclosure through a court
Right.
is going to look an awful lot like it was an intentional miscalculation. Playing games with the ESA payments is the road to ruin.
Right.
That's bad faith in the manner of termination. It's a breach of the employer's duty of honesty and candor with its employees, but it also strikes at the fundamentals of the contract, wages in exchange for service.
Right.
If you're going to start playing games with how you want to calculate the wages at the end of the employment relationship, you're going to get an outcome that you do not want as an employer at trial.
Right. Well,
And-
because in that situation, they could claim more damages, right?
Well,
So it's
well,
gonna
and
cost them
frankly,
more in
like
the end.
the other issue is, these judgments are a matter of public record. And so just as employees or employers who are failing to remit or pay income tax may not want to proceed with a wrongful dismissal matter,
Right.
right? I would say the same for employers who are deliberately miscalculating ESA amounts or who seek to hide an error in the calculation.
Right.
Right, it's a fool's game because there's nothing that prevents that judgment from being read by a regulatory authority. Right, you might get a visit from the Employment Standards Branch.
Right.
I know they're super busy, but you never know.
Moving on to my next question. So, in the instance where an employee may kind of sense that they're potentially about to be terminated, or maybe they've been put on like a performance improvement plan type of thing, what types of things would you recommend that they do, and at what point should they maybe reach out to a lawyer? And can that help, reaching out earlier versus waiting until there is a termination?
What you do in the period immediately prior to termination has a huge impact on the settlement you ultimately arrive at, how quickly you're able to arrive at that settlement, and it also has a huge impact on how much litigation is required to achieve the settlement.
Okay.
So a couple of things. One, if you get in touch with a lawyer before you're terminated, it's more likely than not that you will have all of the records that you need in order to prove your case. We talk about this all the time, right? It's not what we know, it's what we can prove.
Right.
And so if you're at an employer, for example, that is going to turn off your intranet access such that you can no longer access your pay statements, we can fix that, especially if you call us before the termination goes down. If you're on a performance improvement plan, there are two kinds of performance improvement plan. The first is the actual proper performance improvement plan that's designed to help you achieve the expected goals.
Right.
Right? They want to keep you in the system. They want to keep you as part of the employer complement. But where they're struggling is you're failing in a specific area with a specific task.
Right.
Right? Or you're not understanding the scope of the role or whatever the case may be. Performance improvement plans don't have to be negative. But then there's the second kind of performance improvement plan. And it's usually accompanied by something like an offer of an early exit package or,
Right.
An implied termination. You can do the performance improvement plan, but you might want to just quit now.
Or like a
Right.
looming threat, kind
Right.
of like if you don't
So the
improve X, Y, Z.
first problem with that is, I don't know anybody who performs well in those circumstances, right? Whether you're a professional athlete, highly paid investment banker, or a general laborer, nobody responds well to that. It's ultimately self-defeating from the employer's perspective.
Right.
So why are they doing it? Well, they're doing it because usually you're a long service employee or a highly compensated employee, or you've
Right.
just had a big win for the company. For example, you've received one of those balloon payments in the
Right.
12 weeks immediately preceding the termination of your employment.
Right.
But they want to cut headcount, or they need to cut headcount. And so, here you are in this performance improvement plan, and and they know that at the end of the plan, there's going to be a termination. If you engage counsel, counsel can assist you in seeking to meet the requirements of the performance improvement plan, but also in the communications that you're going to write about the plan itself.
Okay.
The terms of the plan, the fact that it's under threat, the fact that some of the criteria are not being enforced equally across the employee complement or with your colleagues, right? Think, for example, sales quotas that change suddenly.
Right.
Or you're selling over quota, but you're not selling enough of product X. But
Right,
nobody is because product X sucks.
Yeah.
Or its price is too high. Those type of performance improvement plans where it's very unlikely you're going to meet the criteria. If you work with counsel during the plan, it's very, very unlikely that you're going to be terminated for cause at the end of the plan.
Okay.
Because the evidentiary record is going to be clear that no one could meet the success criteria anyway. Even if you're on a performance improvement plan, and even if you don't work with counsel during the plan, I want to be careful, but I would say in most instances, employers are not going to be able to terminate for cause anyway. They may allege cause initially.
Right.
They'll likely abandon that allegation early on in the process. And there are a host of reasons that maybe we can talk about that in our next video. There are a host of reasons for that. But the most important one is that the threshold for a performance-based cause, you're so bad that we have to let you go, is very, very, very high in Ontario.
Right.
A lot of employers would say unfairly high.
Right.
We're not management counsel, we're employee counsel, so we don't care. But long story short, if you can't meet the threshold, you're going to pay common law notice, because what we don't have in Ontario is a doctrine of near cause. This is a mistake that employers make all the time. Near cause is the idea that somebody was not a very good employee, not so bad that they deserved to be fired or had to be fired, but, kind of awful at their job.
Right.
So I should have to pay less notice. The problem with that is that if that was all that was needed to be alleged in order to reduce your common law entitlement,
Yeah.
every employer would allege near cause.
Right. Because it's difficult to prove.
Well,
Right.
more importantly, I can't imagine that courts are eager to sit through hundreds, if not thousands, of cases where people are debating how bad was the performance. And again, employers often fail to grasp this very important concept. It's not what you know, it's what you can prove.
Right.
So, for example, with poor performance, there's often not a lot of written documentation. There aren't recorded warnings. There aren't multiple performance improvement plans.
Right.
There aren't last chance letters. There aren't reductions in pay or withholding annual increases, right? And the reason is because performance wasn't that bad.
Right.
They just weren't popular, or they may be difficult to work with, or whatever, right?
But not a valid cause.
You can
for
terminate
terminating.
somebody because you don't enjoy working with them,
Right.
right? Arbitrary reasons for termination are permissible. You just have to either give notice or pay notice.
Right.
It's that simple.
Right.
It's not hard. But unfortunately, and we talked about this before too, termination meetings are hard. Letting someone go is hard. And it's hard not just for the employee, but it's hard for the employer too. There's that real temptation to make it about the employee. You brought this on yourself in some way. Wrong. The person who's getting the bad news is the employee. The smartest thing the employer can do is set the price for the notice a little bit higher so that they're starting the negotiation from a position where they can get to resolution quickly instead of from a position that may lead to litigation. The other smartest thing an employer can do is not pick a fight with somebody on the day that they're giving up all of the leverage that they may or may not have had over that person. Once the employment relationship is over, the employee doesn't care, right? The employer no longer has control. They can't choose shifts. That compensation is not driven by management. There's no bonus to be earned going forward, at least in the eyes of many employees until they talk to us. The person who controls the litigation is not the defendant. The defendant can only impose delay. It's the plaintiff that advances the claim. So you serve the claim, there's a time limit for delivering your defense. If you're late with your defense, get a motion. The defense probably shows up before the motion is heard, but it doesn't matter. You still had to file your motion to get the defense delivered. Guess what? In our system, loser pays. That means that I'm entitled to the costs of my motion, which may not be great, but it's a death of 1,000 cuts. And at the end, the cost award to my time that the employer will have to pay in addition to their own legal fees will be higher, right? It's taking a debt and compounding it with unnecessarily with legal fee cost. Don't do it.
There's an easier way. They seem to.
Well, there's
you
probably
know,
a better way.
There's better way.
And more importantly, what if you down the road you want to hire this person back? Mm-hmm. Well, that bridge is burnt.
Right.
Or what if down the road there's a dream candidate and they call your former employee to find out what it's like to work there? Mm-hmm. Employers think that they have ownership over references. Wrong. And in a market where there's a labor shortage, and a labor shortage that might persist for some time, maybe employers want to think about what people are saying about their workplace,
Right.
and how they were treated on the way out the door.
Well, especially in the court systems, like those are public access, right? So if there is.
Well, leaving aside
history.
the embarrassment of losing a case, or worse, imagine, I can't remember the name of the employer in the at any time case yet, but I'll have it have it at top of mind soon.
Yeah.
But imagine if you're the employer in the Waxdale case.
Everyone knows.
Everyone knows. And imagine if your name comes up in a subsequent wrongful dismissal action. There are other companies that do not enjoy a strong reputation insofar as their employee relations go. It doesn't help them in any way in resolving these disputes.
So I wanted to touch on conflicts a little bit. And I guess being on the plaintiff side, you may not have many conflicts when someone calls you to, seek legal advice. But I just wanted you to speak on that a little bit and how it can influence like the employment legal world.
Yeah, so we only represent on the management side, we only represent employer managed businesses in this practice, and we have a small group of employer managed clients. And we take those clients because they take our advice. But, where there are much larger employers are involved and much larger law firms representing them, it's quite possible that a lawyer who's contacted to act for a plaintiff employee, or maybe a relative, brother, sister, aunt, uncle, whatever, is unable to act because their firm has acted for the employer in the past, or may desire to act for the employer in the future.
Okay.
Right? We enjoy a lot of referral work. And we treat those referrals with great care and great respect. And we don't use those referrals as a gateway or an introduction to those larger management clients, because that's not who we want to work for. It's not who we want to represent. As a result, we do get a lot of referral work from law firms and from large employers through their human resources departments.
So a lot of people know who you are and are kind of.
It's probably, I don't know that a lot of people know who I am or that I particularly care. I think what I'm more interested in is it's the greatest compliment that you could get. If you have to send your friend, your brother, your sister, your relative to get legal advice, you want them to get the best advice.
Yep.
And so when those people are coming here after I've had an interaction with that counsel, it tells me that I've done a good job for my client in that other matter. And maybe not just a good job, but an exceptional job.
Can you tell me a little bit about some company policies that maybe you look out for, or just some interesting ones that you've come across?
So company policies are they're standardized forms. I think at this point, most policy manuals are going to read fairly closely.
Yeah.
I think what's interesting is there used to be an idea, it's called incorporation by reference, where terms that would affect the employee could be buried in the policy, because it would say something in the employment offer like, this offer is subject to all of the terms and conditions in our employee policy manual. And so there were a couple of problems with that. One, the employer would often fail to give the employee the company policy manual with the offer.
Right.
Well, so if you don't know what you're signing, you're not going to be held to it.
Right.
Right? If they did provide the manual with the offer, often it was a voluminous document. And so right out the gate, courts are sort of alive to the idea that it ought not to be fair to bury in 60, 80, 100 pages of size 8 font text a really important provision that has repercussions, particularly post-employment, so after the employment relationship's ended.
Right.
What's really fascinating is there's another recent case where a court found a provision in, I believe it was a stock unit plan, that was unenforceable because it provided for less than the requirements of the ESA. Right? So we've talked about how you can't contract out of the Employment Standards Act. But what was interesting in that case was they used that provision in the stock agreement, whatever it was, to set aside the termination provision in the employment offer. They said they had two conflicting provisions. And the court decided that it would not fix the one provision to make the other provision whole. And so an employment offer, which would have limited the employee to substantially less than their full common law notice entitlement, was struck down because of an overreaching or aggressive provision in the manual. So I don't know that I think there are a lot of red flags in the manuals. I think employers should write really aggressive manuals. I think they should fill them full of onerous conditions that take away things on termination. Because that'll make it very easy for me to set aside their post-Waxdale, post-COVID agreements,
Right.
even if they didn't use the words at any time. And maybe the lesson here is don't do it. Treat people fairly.
Right.
Right? You can enter into a contract that limits entitlements to something less than common law. Just don't go for it all.
But don't try
Right?
to take out the ESA.
Find that balance between the Employment Standards Act minimum payment that you must make and the common law notice that an employee would otherwise be entitled to. It's not actually that difficult to treat people fairly. I understand the challenges in large-scale employment, or I understand the challenges in circumstances where the employment relationship is breaking down. I get it, right? But ironically, the longest notice periods, the most costly notice periods, go to long service employees. If somebody's worked for you for decades, aren't they the most deserving of fair treatment on departure?
You would think.
It makes some sense, right?
Yeah.
And so I often think to myself, I don't understand why employers have such a hard time with the long service employees. I get in Ontario where some short service employees can get very high awards,
Right.
but that's a function of the other Bardol factors, right? The character of their employment, the availability of alternative employment. If you've been extremely successful and you've been promoted quickly and you're making a very, very high wage because an employer recruited you away from your last employer and it's just not working out in the new organization. Well, I hear that you're short service, but you're not going to be able to replace employment at that level of compensation quickly,
Right.
right? Some notice is appropriate, right? But again, it's really, I think the courts, even though employment law is rooted in contract, what the courts want is fairness. And so maybe, call me crazy, but maybe the solution is to write a fair contract. Maybe we should end it there, right?
Yeah. Yeah. Well, this has been great. I learned a lot, and I'm really looking forward to our next chat.
Okay, well,
Yeah.
me too. These are fun.